afternoon, everyone.
Good afternoon.
Welcome to our first Black at Hostos Town Hall event for this spring semester. And let me just share here that Black at Hostos is in its 5th year. And this is amazing. This series started in the wake of international calls for racial justice in 2020, when students voiced their concerns on wanting an avenue to think deeply about issues that impact and shape their lived experiences. President Daisy Coco Felipe, she heard the students and she moved forward with identifying a committee to host these events to create the space for our students. This afternoon, I will serve as the moderator for the series on post-affirmative action and the current climate in higher education. In June 2023, the Supreme Court ruled against affirmative action in college admissions, ending a practice that allowed institutions to consider race in the selection process. What I will say here this afternoon is Hostos Community College is open admissions. All students are welcome, and this is in line with the mission of CUNY, where diversity and inclusion is embraced within the university. All students are welcome in every club in this institution, regardless of race, gender, ethnicity, or sexual orientation. The symbol of 90 flags being displayed on our campus community speaks to our level of commitment. Regardless of where we are, this decision with the Supreme Court ruling against affirmative action, it has had far-reaching impacts for diversity in education, and it will also impact the workforce if you're thinking long-term. With that being said, the relevance of this topic this afternoon does have bearing on the overall state of higher education as we grapple with erosion of legal protections we have had for decades to level the playing field for underrepresented groups. We will explore through this discussion what this ruling means for students, faculty, and institutions moving forward. At this time, to open this event, I would like to take this opportunity to welcome our dear President, Dr. Daisy Coco de Felipes, who will bring brief remarks.
I want to first say that it was a very easy thing for me to say, that's a great idea to the students, right? Because as I'm looking at Professor Burrell, one of the pioneers, right? One of the founding pioneers, and we have with us as well, Professor Stacy Cooper, I don't know if she's here today. She has been, and I cannot wait to hear about your scholarship. We're going to do something with that. Okay, both of you, because you're both doing some really exciting things. Dr. Sofia Oviedo has supported through the Mackenzie Scott initiative some things. Jean Hood Lewis has joined the group this year for the SGA. Our wonderful Vice President, Althea Sterling. I yield to her. Right? And now Michelle Lee in my office. Diana Kramer will be back, and I will stop being an interim participant of the committee once she's back from maternity leave. I want to say how great it is. First of all, I say to Phil, as you know, no good deed goes unpunished. Because Phil is so absolutely kind and professional and gets so many good things done for the school. Forever throwing him into the next event. Right? Thank you, Phil.
Of course.
And he has with him is Mavis Hall. I'm so happy to have you with us, who has been a leader in this area for a number of years. Thank you so much. So I wanted to begin just briefly repeating, and I know, I think I told the group that I had a good mentor. She was the president of Eastern Connecticut State University, Dr. Elsa Nunez, if you want to know. She mentored me when she was in CUNY in the system office as the vice chancellor, and I was a faculty at York. And then when I went to Connecticut as a president, the first thing she did within a month, she showed up And she has sent flowers and what have you. But she showed up and she said, I have two things. First, we're going to have a luncheon at the Hartford Club, and you're going to meet some people who are going to help you. The second thing I'm going to tell you is this. When you're a president, you need to remember that you say something, and then you repeat, and then you repeat, and then you repeat, and then you apologize, which is what I'm doing now, and then you repeat. So since November 6th, as you know, and it's been published and is everywhere, I have said and affirmed the fact that Hostos embraces everyone, every race, every gender, every ethnicity, every religion, every anything. We're an open admissions, we're part of CUNY. We don't use race in our admissions process. And our events, our clubs, and our cultural activities are open to everyone. And I'll go back to give you a little story I told our SGA presidents when I was a faculty member at your college. Keep in mind, one of four Latino in an institution that was primarily black with a white administration, and four Latinos. So this young woman comes to see me. Her name was Maria Lopez. I'll never forget because she was a poet. She was Dominican like me, and she said, I found out you're Dominican. We need to have a Dominican club. I said, Maria, I think there's 10 or 20 students that have to sign up so that I'm happy to be the advisor, but you need to get, oh, she said, that's no problem. So she got black students, white students, Jewish students, Caribbean, English Caribbean, French Caribbean, Central American, South American, you name it. They all signed up, and they said, we want to learn about, there's a big group of Dominican immigrants in New York. We want to learn about them. So the students, another lesson, we learn from the students more than we teach them. Let's stay humble when we understand that. So today is about, this was an event that grew out of the students bringing up, and then having caring, involved, intelligent faculty respond. Nobody, you have to be a fool to think that you lead, and yeah, sure. You have to be a cheerleader and persuade and engage and support. And so my role here humbly is, I'm the grateful cheerleader of some wonderful work, and I like the opportunity to praise and to feature the work of our students, the work of our faculty, the work of colleagues, as in this case, as well, who are teaching us. We will not, and part of what we do, we will not change the nature of what we are. We're going to be making sure that as much information as we can give so that our students who are not documented are protected. We've been giving, as you know, that's part of every entrance of everything. We are not going to put anything out in the press that will bring attention to our students or to the college, but we will continue to have our Black at Hostos, our Dominican conferences, our women's, on Tuesday we have Women in Philanthropy, so there's a group of women who run organizations who are either donors at the school or we're hoping will become donors, who are going to talk about the importance of paying forward, which is also what we saw last semester when this Dominican poor kid from Washington Heights who went on to get a Cornell University scholarship and then went get an MBA as well, gave $1 million to the college, working with a partner to support engineering students. And so we work with everyone because we don't know when the next donor is going to come. And I know that among the alumni of Finale, who's in the foundation, graduated from here about 10 years ago, and he runs a business, and he's already created scholarships. So it is about them understanding. So I say this also to my colleagues here, gently and lovingly. If you're an Hostos alumnus, and I see Mr. Sanchez here, if you're an Hostos alumnus and you haven't signed up or paid your annual dues. Do that now. Do that now. And I remember at York how absolutely engaged the Alumni Association was, that they actually did their own fundraising gala. And used to, at that time, we're talking many years ago, I came here as a provost in 2002, January 2002. So I haven't been back since then. So it's 20 years ago or more. They would raise tremendous amount, 25,000, which was a lot then. But they were always present there also for registration, for events. They were. So I think we need to work a little bit on the constituent group at Hostos as well. I know you said they help you. Maybe they help you more, Mr. Sanchez. So, okay, so this is all I have to say. I'm glad you're here. I'll be quiet. I'm happy to see you, and I'm happy to hear, because as you will see, we're navigating waters. They change rules, they rescind them, then bring them back, they put them forward. In the end, it doesn't change the fact that we are 95% of our student population is majority minority, and that we have the highest number of majority minority faculty, staff, and administrator in CUNY. We're about 67%. Just look at my cabinet. Part of my cabinet is over there. My cabinet is everywhere, everybody. There are people everywhere who represent multiple groups. And so that is it. Me callo. And gracias.
Thank you, Madam President. Representation matters, so I'm delighted to be a part of an institution that truly displayed high level of commitment to diversity. I want to take this opportunity to acknowledge the committee members. Without their help, this would not have been possible. Professor Burrell, Mr. Sanchez, and Professor Cooper. So thank you. So moving right along, at this time, I would just like to take just a brief moment to just welcome our two panelists. Thank you so much for taking the time to be here and to share with us from your perspective and lens of the experience that you've had in your positions. Ms. Mavis Hall is a seasoned higher ed professional, and she has experience in human resources, student affairs, diversity and operations management, and she previously served as University Director of Special Programs, and she has served as the Chief Diversity Officer at Queensborough Community College. So she's a friend to CUNY. I did a lot to get her here, so I'm really grateful. Most recently, Ms. Hall served with Assembly Speaker Jeff Aubrey before he retired last year. Her career has spanned 40+ years of dedication to creating more diverse and equitable spaces in the workplace for first-generation college students and individuals with disabilities. So I'm truly grateful and happy that you said yes. So thank you for being here. We all know Phil, he never says no. He's always here to support us, and I'm grateful that you also accepted the invitation to, speak on this issue, which is timely. We know Phil is our Chief Diversity Officer, so we both have something in common. Your Title IX coordinator, an ADA 504 coordinator for us here at Hostos. We're blessed and lucky to have you. Prior to being here at Hostos, you were a counsel for 200 schools in Queens with the Department of Education. You also have had a career as an assistant direct attorney at Bronx District Attorney's Office in its investigations unit for 5 years. You hold a bachelor's degree in political science, you have a Juris Doctorate from Syracuse, and you're an avid enthusiast of U.S. constitutional law. So I could not have, I've lucked out in having you this afternoon, so thank you for being here. So I'm hoping that we will be able to have a robust discussion, with this conversation that is really a hotbed topic. These are issues that we are dealing with in real time, and these are issues that universities are grappling with. How do we keep up with the speed of the changes while we're still supporting our students and ensuring that we're being equitable in every way that matters to not just our student, but as a community at Hostos Community College. So Phil has decided to give a brief presentation to bring us back to why this all started, why affirmative action, how did it start, and where are we today? How did we get to where we are at this time? Sure. So the floor is yours.
Thank you, VP Sterling, and thank you everyone for taking the time out of your busy schedules to join us for this event. In the interest of time, I'm just going to dive right in. I'm going to talk a little bit about the cases that the Supreme Court has handled over the past several decades involving affirmative action in college admissions. Before that, just a bit of a brief sort of rundown of constitutional law terms that are relevant. It's a bit of a crash course, so bear with me. As we all know, the U.S. Constitution delineates the three separate branches of government known as a separation of powers, right? Article 1 is the legislative branch. It delineates the powers vested in Congress, right? The 435 members in the House, 100 senators in the Senate. Article 2 delineates the powers of the executive, the president, and Article 3 delineates the powers of the judiciary branch, known as the Supreme Court. Now, the Supreme Court actually at the founding of our country really wasn't as esteemed, let's say, as the first two branches of the government until the seminal case of Marbury versus Madison in 1803, where Chief Justice John Marshall, a devout Federalist, he, in essence, created the concept of judicial review. And he said it was found in the penumbras of Article 3 of the Constitution. And in essence, judicial review is a power that the Supreme Court has to review, investigate, let's say, any claims by an individual or entity that believes their constitutional right was violated. And the judicial review is something that the Supreme Court has utilized in every single case that has come before them and in every decision that they've rendered. Okay, and that's where they get the authority to make these sweeping changes in their Supreme Court decisions. Now, when exercising judicial review, they exercise certain legal standards of review. I'm not going to get into deep detail with all of them, but there are three. The strict scrutiny is the highest level of review, intermediate scrutiny, and then there's rational basis review, which is the lowest level of scrutiny. Typically, not always, when rational basis review is utilized, a law typically stands. Now, with respect to strict scrutiny is utilized by the court when it implicates a particular constitutional right, such as, for example, the First Amendment, right? Freedom of religion, and when it involves the Establishment Clause, or the freedom of speech or freedom of the press as it relates to communications and FCC regulations. And most notably, and which is most relevant today, the Equal Protection Clause of the 14th Amendment, right? Equal Protection Clause of the 14th Amendment is found in Section 1 of the 14th Amendment, which is one of the three Reconstruction era amendments that were ratified in the mid-1800s. And it states that no person, no citizen, born or naturalized in the United States shall be deprived of life, liberty, or property without due process of law. And so we're going to be talking about affirmative action here, right? And that's a race-based topic. And as a result, the Supreme Court utilizes strict scrutiny when it decides or renders its decision on a case. Something to keep in mind, strict scrutiny assumes that a law is invalid, and the burden is on the government or the entity that's imposing the law or the practice to articulate that they have a quote-unquote compelling interest to achieve, that it is the least restrictive manner in which to achieve that compelling interest, and that law or policy is quote-unquote narrowly tailored to achieve that compelling interest. And so strict scrutiny over the years has been used in some cases in horrendous decisions like Korematsu versus United States in 1943, where an executive order was issued by FDR requiring that all Japanese, German, and Italian Americans be placed in internment camps. Supreme Court utilized strict scrutiny, decided that it was a constitutional executive order for the compelling interest of preserving national security during wartime. Okay? I disagree with it. Many analysts have disagreed with it, but that was an unfortunate decision. But strict scrutiny was also utilized in positive ways as well, right? We're most familiar with Brown v. Board of Education of 1954, which ruled that separate but equal doctrine was unconstitutional, right? And that had broad sweeping changes, and it precipitated the Civil Rights Act of '64. Strict scrutiny was used in Loving v. Virginia of 1967, which overturned a Virginia state law banning interracial marriage, right? So strict scrutiny has always been utilized in affirmative action cases that has been brought before the Supreme Court, and that's where we're going to jump into. The first case I want to talk about, though, actually doesn't address affirmative action in higher ed institutions, but it's still important, and I'm going to circle back to this case at the end when I finish talking about the handful of cases, is San Antonio Independent School District versus Rodriguez in 1973. Rodriguez was a plaintiff, one of many families representing a group of plaintiffs that were living in the San Antonio School District. They were the plaintiff initially, and they prevailed in a lower court, and the San Antonio School District appealed all the way to the Supreme Court, and that's why they flip-flopped. Now, the case was basically that families that were in one district in San Antonio that were poor and overwhelmingly Hispanic, they were receiving, their schools weren't receiving the same resources that an adjacent school district that was way more affluent and majority white were receiving. Those schools in the adjacent school district had better academic facilities, teachers, supplies, relative to the Rodriguez and their fellow community members. They argued that it was a violation of the Equal Protection Clause because the distribution was wealth-based, and there was a pattern that was indicative of race, that was, in essence, creating this discrepancy between both school districts, or communities, rather. They also indicated that education is a constitutional right under the Equal Protection Clause, life, liberty, and property, and they sort of argue that under life and liberty, education should be included. The Supreme Court, this is one of the worst decisions in my opinion. Supreme Court ruled that education is not a constitutional right, is nowhere mentioned in the Constitution, and that wealth is something that's also not constitutionally protected, or the disparity thereof. These are things that, unfortunately, are not covered under the Constitution. And also, education is a state's responsibility, so the federal government should not get involved. And the Supreme Court decided to overturn the lower federal court and rule that San Antonio's distribution of resources was, in fact, constitutional. Again, important to just keep in mind, I'm going to circle back to it. The first case that the Supreme Court addressed regarding affirmative action was University of California, Davis versus Bakke in 1978. Bakke was a med school student. He applied to UC Davis's med school, which had only 100 seats. 16 of those seats were specifically reserved for minorities. Bakke actually prevailed in the lower court, UC Davis appealed to the Supreme Court. The Supreme Court confirmed the lower court's decision, and Bakke was allowed admission. But the decision was twofold. The Supreme Court stated first that strict racial quotas are in violation of the Equal Protection Clause of the 14th Amendment. That a school can't just have these strict quotas, like let's say 5 seats or 10 seats just for minorities. It has to be included, and this is the second part of their decision, it has to be one of many factors that the admissions office of a higher ed institution needs to consider. It can't just be the sole factor, which isn't necessarily accurate, because the 16 students or applicants rather that they choose, they have to also be qualified, right? It's not just 16 people they pick, off the street. But nonetheless, that was a decision of the Supreme Court that basically persisted for decades. And so it ruled affirmative action is allowed, but it can't have strict rigid race quotas. And there was some back and forth over the years. Supreme Court didn't want to hear anything. They relied on Bakke as the rule of the law, as the law of the land when it pertains to affirmative action and admissions, until 2003, when the Supreme Court decided to take 2 cases that were similar, but the decisions were very disparate. And the first was Grutter v. Bollinger. Lee Bollinger was the president of University of Michigan, and Grutter was a law school applicant who applied to the University of Michigan Law School and was denied admission. She argued that there were students that were admitted that didn't have the same qualifications. They were only admitted based on their race, and as a result was a violation of the 14th Amendment. Now, in that instance, the University of Michigan Law School's admission policy used race. It was consistent with the Bakke decision. They used race as one of many factors in their admissions process, right? They included grades, LSAT scores, community service, et cetera. And the Supreme Court determined that the compelling interest of achieving diversification in the student body, that's a compelling interest. And their admissions policy was narrowly tailored by utilizing multiple factors and not just race in determining whether someone's admitted or not. Okay, they affirmed or confirmed the Bakke decision, and Grutter wasn't allowed admission. Now, a different case still involves the University of Michigan, but their undergraduate school. Gratz was an undergraduate applicant who was denied admission, and Michigan's undergraduate program, they had a point system where they would award like 10 points for SAT scores, 10 points for a GPA of above a 3.6, it's not weighted, 8 points if you're a minority. And so the court in this decision, in Gratz, they actually deemed the University of Michigan's law school admissions policy as unconstitutional because of the points system. That point system was not narrowly tailored to achieve that compelling interest. So Gratz was actually admitted to the University of Michigan undergraduate program because the Supreme Court found that in this instance, it didn't survive the strict scrutiny analysis and was indeed a violation of the Equal Protection Clause, simply based on the point system. Okay? An interesting thing to note, in the Grutter case, Sandra Day O'Connor, who was the first female justice to be nominated and selected to the Supreme Court back in 1981, she stated that affirmative action is just a temporary tool, because in 25 years, it's not going to be needed anymore. Now, I don't think she's that dumb to believe that. I think she was probably placating a certain constituency, because as you know, like, we still are having these issues today, right? And we still haven't achieved the goal of diversification, not even remotely close. But something to consider, because that concurring opinion by O'Connor is something that the most recent Supreme Court case in 2023 relied upon. The next case, Fisher versus University of Texas A&M. It was first presented to the Supreme Court in 2013, but they referred it back, or remanded it, rather, back to the lower court because the lower court didn't utilize strict scrutiny when they should have. Fisher lost the case. She still appealed again, and the Supreme Court finally said, okay, we'll hear it in 2016. Supreme Court ruled that the university's policy met the strict scrutiny standard. There were no rigid racial quotas. There was no point system. And they affirmed the constitutionality of race-conscious, not race-based, but race-conscious admissions policies, because the race-conscious admissions policies includes race as one of many factors in determining whether someone's admitted or not. Okay? And they were able to justify this necessity of diversification through measurable educational benefits. In essence, the University of Texas provided data and evidence to support the positives of diversification in their student bodies. And then finally, most recently in 2023, SFFA, Students for Fair Admissions versus Harvard and University of North Carolina, Chapel Hill. The plaintiffs were represented by SFFA, but they were Asian American students that were denied admission to both schools. And the seats were provided to African American and Hispanic students. The Supreme Court ruled that their race-conscious policies, which, remember, in the previous decisions, the precedent from the Supreme Court said that race-conscious policies are constitutional, they're okay. Supreme Court overturned Grutter and Fisher and parts of Bakke by saying that even race-conscious policies are in violation of the Equal Protection Clause of the 14th Amendment. That race shouldn't be considered at all in someone's in a higher ed institution's admissions policies. The court said that the policies were too broad, not narrowly tailored, and they lacked a clear end point, referring back to Sandra Day O'Connor's concurring opinion. Now, this is the part of my presentation where I want to talk about alternative methods and strategies that higher ed institutions can utilize to still achieve diversification. And this goes, we're going to use their rationale against them, in essence, going back to San Antonio versus Texas of '73, where they say that education is not a constitutionally protected right, and wealth, finance, right, is also not a constitutionally protected right. So if an admissions policy that relies on those two aspects is brought to the Supreme Court, they're going to have to utilize a rational basis review based on the San Antonio v. Rodriguez case. And so what are some alternative methods that we can utilize to still achieve diversification in our higher ed institutions? One of them is socioeconomic-based admissions. And by the way, I have a few slides here. It's interesting to note, and you'll notice this, I hope, Hostos utilizes these mechanisms and has even before 2023. Socioeconomic-based admissions, where we give preference to applicants from low-income families, considering family wealth, parental education levels, and their access to resources and education. Geographic-based admissions, where we recruit from high schools with lower college enrollment rates, or setting aside admission slots from students from economically disadvantaged zip codes, right? Holistic admissions with an emphasis on overcoming adversity, giving weight to applicants who have overcome significant hardships like poverty, homelessness, discrimination, which we can get from their essays and interviews, and increased recruitment and outreach efforts, where our outreach programs that provide college prep resources to communities that are underprivileged and underrepresented, all right? And I also mentioned like test optional and holistic evaluation of academic merit. And these are things that that community colleges across the nation have utilized for years. Now, these larger universities and colleges, they're utilizing the tactics and strategies that community colleges have used over the decades to achieve this diversification in light of this most recent Supreme Court decision. So all is not, dark and morbid. There are ways, legal loopholes, that we can navigate through to achieve the goal of diversification.
My last position, working the opportunity programs, was looking at students who were not admitted to CUNY overall because they lacked the academic success from high school to have like the average. They were low income and they were pushed to the margins because like they really didn't think that they could come to college. So are you familiar with the Seeking College Discovery programs? They are the programs that kind of changed. At one point, are you aware that CUNY used to be free? Yes. And so if you look at the history of CUNY, and then there was a big push to kind of let other people who could not come get in. And so the model is there, like you said, in terms of looking at those. And it's great to be in New York right now because you talked about the government. So Seeking CD came out of a civic engagement where students were really seen as being important members of the communities of their representatives. And I'm not familiar, are you familiar with Percy Sutton? So are y'all familiar with how Seeking CD came into being? So they went in fighting for, they had to come back. Their votes were being rallied. People wanted them to vote, and they said, well, I got to go back with something for my people. And so they were able to get the funding for the Seeking CD programs that have been around for about 60 years now, based on the model of providing socioeconomic, social, and financial support for students who didn't think that they would ever get into college. And so being a part of New York, where the government can kind of push back from the state level to the federal level, we are in, I think, a better place than most.
Yeah,
and if California and New York, I think, will be okay if DOE gets to dissolve, because if we withhold our money, we could support some of the stuff that we are still trying to do. But it's just, let me go back to thank you all for allowing me to come, because this is my soapbox. I applaud you, and I thank you, President, because of the environment you have here, the culture you have here. I am a recovering Chief Diversity Officer. Because I have been fighting this thing. I've been in this battle for years. I mean, let's go back to before affirmative action, it was EEO. How do we level the playing field where people were not being considered for jobs because they didn't look like everybody else? The net wasn't broad enough. So it was really about broadening the net to cast it and open the doors so that you could find more qualified people that don't look like everybody else. That makes sense, right?
Yeah.
So it's just interesting that as we go to affirmative action, and I used to write affirmative action. Remember the affirmative action plans you have to write? And it's really basically looking at your demographics, who do we have, and then who are the people that have the requisite skills to fill the jobs that we have. And most often than not, they search in the same places to find the people to. So it's like bean counting, and then you saw the shift. You went from, you were white, black, Hispanic, Asian, Pacific Islander, Native American, to population shifting. Tell us, are you Hispanic or non-Hispanic? And then tell us if you are white, black, da-da-da-da-da. So you saw the shift, and then the fear that we're experiencing, where they're reacting from, is that, and that word minority. They say minority for people of color, but there are more of us. So we got to kind of look at that, and that's what's kind of driving a lot of what we're experiencing, because there's a shift happening. And that's the only constant in life, right? Things are constantly changing. So how do we flex and move with it in a way that we don't lose sight of what the mission is? And so the mission here, you all know the mission here at Hostos. How do you not lose sight of the mission? And you shift and you flex a little bit so that you do the things that you mentioned. And I think it's all about what you're doing right here. It's about staying true to your course, staying true to the fact that you create community. Open, you said you open, so everybody's welcomed in. And then within that open policy, you actually have places where people can connect with people just like them. So you need to really keep doing what you're doing, being mindful that there are some running to the shadows because they are really dealing with, their fear is real. So how do you create space for them to be comfortable and hold both the fear and the hope? How do we give more hope? Because I don't think, as I sit here in my own tradition of faith, faith and fear can't be in the same place. So how can you give hope and faith to somebody and to each other? You got to be in community to do that. So like when you're down, I can kind of help lift you up, and when I'm down, you can kind of help lift me up. So keep doing that. And then I always like to ask people, do you know who your electeds are? For where you work and where you live. And I was able to kind of model that for my students in that I live in Queens, which is, we like to say we're the most diverse in the world, right? So I live in a community that we have a large immigration population. And so for me, it's important to have people know that I care, because I know that there before the grace of God, I can be in the shelter. I can be dealing with the same issue. So just being able to model it with my students, where I was able to take them to Albany and let them meet with their electeds, identify them, identify the issues that are important to you, what are their issues and what can you connect on. And then my assembly person met them, spoke to them. So he helped me model what I was trying to show them. And then in that connection, that's another thing you can do if you're comfortable with, the political side, because it's very political. And we've had the fortune of actually having some of our students become elected, so they can see that that's an opportunity to get on the other side. Khalid Anderson, I think, is one of those Sikh students who came out of Queens College, who's now an elected assembly person. So like he's one of our pride and joy. So it's getting them to see their own power, to find their own voice, and then having everybody stand together is really important. And I think that it's important to know the law, but politics is local. So it's important to know the people who are making the law. And it's also important to connect the people who are living the law to get their feedback. And so what's interesting now is that those who didn't think that they would be touched by this are experiencing that poem. Do you remember the poem, like when they came for this population, nobody spoke up. When they came for that population, nobody spoke up. And then when they came for me, there was nobody to stand up. So it's interesting to be able to kind of be in a place to actually see that come to life, right? And so I have to say in my faith tradition that we all have to realize that we are the answers to the prayers of our ancestors who did so much with so little to get us to where we are now. We are, I am, you are the answers to the prayers of our ancestors who died and went through so much to get us to where we are now. So this struggle is the new flavor I was saying. Yeah. But it's not new. And then for them to think that 25 years, what did Sandra Day O'Connor start, 25 years would be enough?
Yeah.
And I'm like, okay, the math is not mathing, because 1619 is a date that we know slavery happened, right? 1776. So like we were helping, people of color were being brought here to build this place before they even, we were helping the colonizers colonize, right? So then now when we get to a place where we had the laws passed to give us what we worked so hard for, and then now they want to use it against us, so now they're saying that we're discriminating because we want, I mean, it's just, so, but don't get distracted by the chaos, because I think that's the strategy. Throw so much at us that we're like, what?
Right.
Stay focused on the mission. Mm-hmm. We are not going back.
No, we're not. We're
not going back. Too much has been invested and too much has been sacrificed. And look at yourselves. This is beautiful. Diversity is beautiful. I mean, it's like, so it's just really interesting that education is that thing that they're trying to dismantle, because when I think about it, my grandmother and my mother always said, get your education, because once you get that, it can never be taken from you. Yeah. And then that goes back, if you know our history, they didn't want us reading. Yeah. Mm-hmm. They didn't want us reading or writing. Yeah. And then there's stories about, who was able to slaves who were able to kind of outwit the slave owners and get their children to teach them how to read. And there's stories about how they were able to use the reading and the writing to write the passages that they needed to navigate. So we need to kind of hold on to, we are the answers to our ancestors' prayers, and use some of the tactics that they used, and be prayerful and build our faith so that we can tap into that resource, so that we know that, God is on our side. He didn't say it was going to be easy. He just said he would never leave us. God is on our side. We're going to get through this because he's gotten us through other things. And we can look at the history. What's the Sankofa bird? You feet forward, but you look back so you know where you're coming from as you move forward. You got to kind of tap into all that you know. If you don't have a faith story from your family, go get you one and hold on to that. Like, that's an example in my family that we did this, and we can do this again.
Thank you. Thank you for that. This was very insightful. My panelists don't really need me. And it's interesting, I want to share briefly how I met Mavis. She is a strong advocate for the voiceless, and I met her like 2 years ago. I think it's 2 years ago. She took the charge of supporting single mothers who were in a shelter, and she wanted to create some space where they feel valued. During the Christmas, you wanted to distribute toys to the kids, so it did speak to her strength and value in ensuring that she creates spaces where inequities exist within the community. So when I thought about this topic, I thought about bringing her on, so thank you for sharing that. What's interesting about this is, as we go through the history and as we go through all these legal cases, and also the strict scrutiny is what got us here, right? Both of you are chief diversity officers. This kind of work is heavy. It's not easy work. What really drove you to this kind of work, and what do you find to be most rewarding as you think about the challenges that constantly we're dealing with on a day-to-day basis?
You want me to go first?
Sure.
I have to say that I need my life to be something that adds value. I'm a long hauler, COVID long hauler, and I said, God, you kept me here for something. So when you asked me, I'm like, well, yeah, because I think I have a lot to say right now, especially now. But I've always wanted to make sure that I can make a difference in someone's life. And I say I'm a recovering chief diversity officer because all the places are not like Hostos. And I've done diversity work in corporate, and I've done diversity work in CUNY. And the challenge is always getting people to define what diversity is. Like even with this Dear Colleagues letter, they keep running DEI, but they don't know what it is. And so they have people scrambling, trying to change and stay on par, but they're not really giving you guidance on what it is that they're looking at. So it's really more chaos. But I've always wanted to make a difference in. The challenge is always getting people to see that they are important, and I wanted to have people know that their voices are heard, whether it's in corporate, whether it's in as a chief diversity officer on campus, so to help everybody know that they are involved in creating the culture, and that they bring a lens through which they see the world, but that lens can kind of be changed a little bit if they broaden it to include more people.
I mean, for me, I've always felt that incorporating diversification would only lead to greater advancement and social evolution. I always think about all of the lost opportunities we had by subjugating so many women, African American, Black communities, Hispanic communities, that if they had the opportunity to achieve the education that you can't take away from, how much more advancement could we make in the arts and technology and science and everything? And personally, for me, I'd see it, like I said, I'm a con law enthusiast, et cetera, and I just noticed that the decisions, particularly from the Warren Court, that were progressive always led to more positive change and growth. I always wanted to be a part of that. I don't do this, for the money. I do this because I know that I have this moral satisfaction that accompanies the work that I do. And Mavis, to your point, diversification is difficult. Fortunately, I'm in an institution that embraces that, and I'm lucky and fortunate. I'm grateful for that. But particularly in like private sectors, it's much more difficult. And what's happening now currently with this current administration, they're just clouding people's perspectives. Like you keep using that word chaos, and I think that's a very applicable term. They're purposefully and intentionally doing it. And frankly, I'm looking at it from a legal perspective. As an attorney, it doesn't make sense. That Dear Colleague letter, particularly the one where they're saying that the SFFA decision also says that entities, both private and public, can't. The case, that's not true at all. That Supreme Court case simply talks about admissions policies and affirmative action, not DEI. And also, in embracing academic freedom, we have to understand that the First Amendment's freedom of speech protects us as academic institutions to talk about issues of diversity, equity, inclusion, right?
Exchanging of ideas.
Exactly.
I mean, it's an institution of higher learning. So.
Right. Cultivating student organizations that represent different identities and stuff of that nature. So if they want to take it to that step where they're going to also, violate a First Amendment right, they're going to lose a lot of legitimacy, whether that matters or not. I mean,
how do we hold them to what
correct.
The courts?
How do we hold them accountable?
Where do we go from here as we think about students, educators, and our community members? What are some thoughts that you have about how we continue to advocate for continued equitable access to higher education as we move forward? What are your thoughts on that?
Some of the slides that I presented a little earlier, I think, demonstrate that, right? Having a more holistic approach to admissions. This is more applicable to these larger national universities and colleges that have all these resources and all this money, because as I alluded to earlier, community colleges have been utilizing these methods, right? And now it's their turn. Now it's these national universities and colleges that are starting to embrace these strategies. And I think it's going to be effective in achieving that goal. Not just the socioeconomic factors, but also just considering, like exercising empathy when, as best as they can through these there's hundreds upon thousands of applications they receive, but it's a matter of really trying to reach the student's perspective through their essays and interviews and seeing, where they're from, and not just looking at scores, GPA, and because typically that could reflect one's, students'
Not having access to resources to get the scores
exactly.
up. Their living situation may not be a place where they have the support to
right.
be able to
Low-income
study
families.
and focus and eat, to feed the brain and
right.
all of that. So the holistic approach.
Correct.
Yes.
And I think that's the best mechanism at this juncture that can be utilized to achieve, diversification. And then, always maintaining this like momentum on the ground at the college, the school level, where we support, I believe in like student groups and organizations that represent a wide range of identities and supporting those. And I received some questions where, here, can we do this event, and can we do this because of this, and I personally, I believe that we can. The First Amendment protects us from doing so. I don't think that the Supreme Court decision, despite what this current administration interprets it as, does not apply to that. And I just think we just need to forge ahead. There's also a preliminary injunction that was issued by a lower federal court recently because there was a lawsuit that has placed this executive order on hold for the foreseeable future until a decision is rendered. So we just keep forging ahead.
Thank you. While I was thinking about this presentation, I thought about our students, right? I thought about students who want to transfer. It's a reality that we do encourage our students to transfer to CUNY institutions, right? Yeah. Okay, thank you. You really didn't leave me, but